All right. Good morning, everybody. This is John Baker. I'm a real estate attorney, and let me get rid of that. And today we're going to talk about SB9, which was just signed into law last Friday. So I thought we'd talk about that. This is one of three bills that was passed, 8, 9, and 10, and they make it easier to get a duplex on your property. So I'm going to start sharing my screen here. And here we go. So I'm John Baker. I'm a real estate attorney, and my office is here in Irvine. And let me switch over again. So before I get started, though, I want to remind everybody that I would really like to have your suggestions for things to talk about here. Alex was talking about a conservatorship. I don't really do conservatorships. That's more of a probate kind of thing. But if you have a real estate related matter, I'd certainly like to hear what you have. So again, as I was saying, we're going to talk today about duplexes and lot splits. Senate 9 deals with both of those. It was soon after the election, a couple of days after the election was over, Governor Newsom signed this law into law, and it requires or allows it deals with proposed urban housing development or lot splits. It can only be for 2 residential units or 2 parcels, and it has to be within an urban and a single family residential zone. The interesting part is that everything through this, if you do it right, is considered ministerially. There's no discretionary review, and there's no hearing. So that means you should be able to get through much more quickly than before, and with a lot less headache. However, the proposed housing development does have to meet certain requirements that we'll talk about. Interestingly enough, in order to be able to do it ministerially, you have to meet objective criteria and get your building permit or your parcel map. Now, for both the housing development, as they're called, or pretty much duplexes or lot splits, there are certain common things to talk about. First of all, the parcel must be in an urbanized area, not a rural area, I guess. It has to be in a single family residence zone. The local agency, which would be the city or the county, can only impose objective zoning standards, objective subdivision standards, and objective design standards. In other words, there's no leeway. If you meet these criteria, then you get the permit. Objective standard means that there's no personal or subjective judgment by a public official. If you meet the criteria, you get it. And you have to, what objective means is that you can find out what these standards are online or in the book, and they're the same standards or the same information that's available to the official who's going to be looking at your request. And a couple of little requirements is that these objective standards can't have the effect of either physically precluding the construction of 2 units or physically precluding it sounds like it's both the same, but remember, it's either for a parcel split or for adding a new unit to the property. So you need to be able to do both of those. So the local agency can't create these rules that make it impossible to get either one of those. Each unit has to be at least 800 square feet in floor area. They can't, in certain situations, they can't require setback requirements. Otherwise, it can only be 4 feet. As you might expect, the parcel can't be on a whole bunch of things: prime farmland, hazardous waste, earthquake fault zone, special flood zones, and things like that. Again, the project can't require the demolition or alteration of housing if the rent levels are already restricted to moderate, low, or very low income. In other words, either by law or by something that's been recorded. Again, you can't, if project can't require demolition or alteration if the parcel is subject to rent control. Now you may be thinking, well, the whole state is subject to rent control. Well, you may recall also that there is one carve out, and that is for single family residences. So single family residents can avoid the statewide rent control law, assuming they give notice to the tenant. So that's how, but somehow if there is some local area that does have rent control on a single family residence, then you might not be able to do this. You can do any demolition or alteration if it's been occupied by a tenant in the last 3 years. Again, we're still talking about the criteria for both duplexes and lot splits, but there's a variation here. If you're just going to do a housing development, in other words, you want to turn your single family residence into a duplex, or you want to put a ADU on it or something like that, then an alternative dwelling unit, then you're going to be required to sign a declaration that you intend to live as in one of these units as your principal residence for a minimum of 3 years. However, if you're getting a lot split, it's a little bit variation, and because SB9 requires that use only be for residential uses. So I don't know how they're going to carry that one out. Again, we're still talking about criteria for both duplexes and lot splits. This is the mandate. The SB9 says that any rental has to be for longer than 30 days. You can't do shorter terms than that. It also prohibits an agency from imposing any additional owner occupancy standards on the applicants. In some situations, the local agency can require off-street parking of only 1 space per unit, but there's carve-outs if you live close to transit there. No, it is really interesting. Normally, an environmental impact report would be required if there's a significant effect on the environment, but because SB9 makes this a ministerial process, it's exempt from the California Environmental Quality Act, or the CEQA. Same thing with the Coastal Commission. If you're trying to make changes near the coast, you have to get your Coastal Commission permission. But because, again, this is ministerial, the local agencies are no longer required to hold public hearings for coastal development permits. Now we're just going to talk about the development part of it, about household development. And most of the requirements we've already talked about for that, but there is this one other one. If you're trying to, you can't demolish more than 25% of the exterior structural walls unless the local agency passes an ordinance saying that it's okay, or the site hasn't been rented for the last 3 years. Remember, the whole process, the whole purpose of this one is to create more housing. And so that's why there's these limitations on what you can do if it's already a rental. So now we're going to talk about what some of the other criteria is just for getting a lot split here. Again, it's approved ministerially, If you do it right, if you can shoehorn your project into this deal, one of the requirements is that the lot split would create no more than 2 parcels of approximately equal area. So in other words, it can't be a less than 40%. One property can't be less than 40%. The parcels can't be less than 1,200 square feet. So if you've got a really small lot, say under 2,400 feet, you may not be able to do it unless the local ordinance allows for a smaller lot size. Again, that would be something that the city or the council would have to pass an ordinance to do that. Parcels can't be established through prior urban lot splits. In other words, you can't split your parcel into 2 parcels and then come back and take one of them and try and split it again and multiply it that way. They don't want you to do that. Same kind of thing, you can't assemble several lots, like 2, 3, 4 lots and say, here, I'll pay for you doing a parcel split and then I'll buy your property. So if you have a property, if you've subdivided a property into 2 parcels, you can't do it to the adjacent property. Again, the local agency is not required to permit more than 2 units on a parcel. Notice the way it's worded. If the local agency wants to allow it, it can do that, but it's not required to allow you to put more than 2 units on a parcel. And notice that unit means, or dwelling unit means just about anything. It could be the primary house that was on the property. It could be an ADU, or it could be this project that you're trying to get your permit for. So as I said, an application for a parcel map shall be approved if it ministerially. There can't be any discretionary review on this. But it's only for residential uses. And it has to conform with objective requirements of the Subdivision Map Act. And interesting enough, you won't be required to fix any of your non-conforming zoning conditions in order to get this permit. They also can't require you to do dedications of right-of-way or construction of off-site improvements like street lights or anything like that. However, they can require easements for public services and parcels and access the public right-of-way. So in other words, if you've got a unit behind, somehow that unit behind needs to have access to the street. There's very few instances where an agency can deny a permit in this kind of application, but they can do it if you're if you already have 2 dwelling units on there. The only other instance is if there's a health or safety issue, and then they have to write it up and show that that can't be fixed in one way. So that's, in summary here, it's much easier now to get a building permit or a parcel map for 2 residential units or to create 2 parcels. You just have to meet the objective criteria, and it's all done ministerially, and there's no discretionary review. So with that, I'm going to stop. Again, I want to ask you to send me any ideas that you have for the next project or the next presentation that I do. And if you have any questions, please give me a call. John Baker, Baker Law Group. I'm a real estate attorney. Thanks, John.
Thank you, John. And now it's time for the membership with Lou Elliott.
Good morning, Riak. I'm waiting for you to put up my slide.
Yeah, hold on. I'm going to stop the recording too.